I have a fiduciary relationship with the seller, so I really can't talk about that. Okay? So I want to talk about at least two of those three things right now. If you look at this blacked out, redacted correspondence, this is a real letter taken from the real files, taken from one of my real files. This is a letter written to my client by a lawyer who is referencing the fact that his clients bought a house that was riddled with stucco issues. And remember what I said earlier about don't be the weatherman. Don't be the stucco expert. You're a real estate salesperson. You don't know diddly about stucco. You don't know anything about the manner in which a home is constructed or whether it's good, bad, or indifferent. You want to steer that client to the right professionals. But here's what this genius does. Buyer. That's fine. We don't need stucco. Agent. Not unless you wanted to specifically have that done. Stucco and EIFS are two different types of stucco. Correct statement, yes. Stucco and EIFS, EIFS being synthetic or artificial stucco as opposed to Portland cement, which is real stucco. So far, he's correct. This home is not EIFS. That's the one that has a lot of issues. Wrong. Completely wrong. It's the other way around. If you wanted to have that done, and it is not cheap. Wow. Shades of my $7,000 client. I've had a buyer do it before, and it cost nearly $2,000. We can schedule. Only problem is we did not specify we were having that as a special inspection. No, you probably didn't specify that, but you specified you were having a home inspection, and if the home inspector is telling you you need a water intrusion inspection, then you reply, we need a water intrusion inspection, and if the seller says no, you say, LG, bye-bye. Agent says, therefore, if anything were to come back as wrong, the sellers won't be at fault since we didn't specify it. This only gets worse. I've only had one of those done in 3 years, and it will be it was because the home was EIFS. Buyer. Buyer's smarter than the agent. The buyer says, let me do some research and come back. Just do not want to deal with mold issues later on. Agent, okay, well, need to know shortly because our inspection is set for this Saturday. And then he goes on again. Stucco and EIFS are two different things. Wait till you hear this. The home's only 8 years old. I obviously can't guarantee you there will never be a problem, but stucco wouldn't be used on these homes if there were problems. Okay, just keep digging until you're down about 6 feet and then jump in and let them cover you all up. So, the black and the white of what I'm telling you is you want to, what I told you in the beginning of my talk is while you want to confirm the conversation that you have with your client, you want that to be contained to those things that you agree upon based upon your advice. And you never, ever want to give advice to your client to avoid an inspection. You want to say, hey, if this guy had any brains, any skill, any training or any expertise, he would have said, I don't know whether you need a stucco inspection or not, but I can recommend a couple of inspectors to you if you decide you want to go that way. Yes, sir.
Question. On this dual agency situation, what was the fiduciary responsibility of the agent in relation to the buyer and the seller?
Okay. Good question because it allows me to segue into what I want to talk about next. And
also, too, I noticed in the consumer notice thing, there's a little sentence in there that says if dual agency occurs, there has to be disclosure evidenced in a writing.
yes. Yes. A year ago, I spoke at, maybe 2 years ago, I spoke at NAR at the national conference in Washington, D.C. And there was a room of, I don't know, 500, 600, 700 people there, and I was discussing some of these same issues. And every once in a while, I had to qualify what I was saying because I could only speak for Pennsylvania, where I practice law, and there were agents in the room from all 50 states. And at one point in time, I mentioned dual agency in Pennsylvania. And at the end of my talk, this guy comes up from all the way in the back of the room, and he's about 6'11", and he's wearing a cowboy hat and boots and one of those bolo ties, you know? I mean, the guy was like right out of a Gene Autry movie. And he says, son, you mentioned something about dual agency. What is that? And I said, well, in Pennsylvania, an agent can represent both sides to a transaction. And he looked at me with great puzzlement on his face, and he said, you mean if I'm an agent in Pennsylvania, I can represent both the buyer and the seller? And I said, yes. And he took off his hat and he slapped it on his leg like Walter Brennan. And he said, I believe I've now heard everything. And I said, yes, you should come home with me for a couple of days and see some of the files in my office. I talked to Debbie about this yesterday, about dual agency, because I was sort of trying to take the temperature of the room here in terms of how many of you do it and how many of you avoid it. And Debbie sort of suggested that there are a number of agents in this office who do it and who like it. I hate it. And the cases where I have seen agents get in the worst fixes, get in the deepest holes out of which they sometimes cannot climb without paying a lot of money, have to do with dual agency. I understand that the Pennsylvania legislature has written a law that says you can represent both sides in a transaction. Legally speaking, you can't do it. Yeah.
What about designated agency? How do you feel about that?
Well, let's talk about dual agency first, because I want to give you a hands-on practice examination here. Somewhere in this handout, there is a page from the 2014 Agreement of Sale, and it's page 12 of 13. And I only included one page in the handout for expedience sake, because I wanted you to take a look at paragraph 28, release. But before you do, I want you to put yourself in this situation. You're the listing agent. You happen to be here on a Sunday afternoon, and a buyer walks in the door and says, hey, I've just driven past the house at 123 Main Street, and I'm interested in that place. And that's your listing. And you say, well, are you represented by an agent? And the buyer says, no, I'm relocating from Timbuktu, and I don't know anybody around here. And the conversation then, of course, grows into how you can represent that buyer while still representing the seller. And you give whatever explanation you have to give that makes sense to that buyer to encourage the buyer to allow you to be a dual agent. You take the buyer to the property, buyer likes the property, buyer says, I want to come right back to your office and write up an offer. I want to pay full price. I don't want to mess around. That's the house I want. Let's do it this afternoon. You're thinking, this is my lucky day. This is great. This is great. I'm going to get both sides of this, and I'm going to be on Fat City. So let's sit down with our buyer, and let's go through the agreement of sale. First page has to do with terms and conditions, has to do with sale price, has to do with closing date, has to do with mortgage contingency, has to do with home inspection, radon, termites, the whole thing, has to do with the quality of title. You get all the way over to page 12 of 13. You're almost there. You're almost to the point where the buyer's going to sign this thing, and you have to explain to him paragraph 28. And you say to your buyer, this says, buyer releases quit claims, whatever that means, and forever discharges seller, all brokers, their licensees, employees, and any officer or partner, or any one of them, and any other person, firm, or corporation who may be liable by or through them from any and all claims, losses, or demands, including but not limited to personal injury and property damage coming from mold, septic, water, fungus, structural damage, whatever it is. If there's a defect in the property, you sign this agreement of sale, you're giving up your right to sue the seller. How can you do that? Are you encouraging that buyer to give up a right, the result of which will be favorable to the seller? Or are you saying to the buyer, hey, listen, if I were you, I would strike that out, because you don't want to give up your right to sue the seller. But the minute you do that, you're going against your fiduciary duty to the seller. So my suggestion to you, and this is played out in many courts of law where I have personally been present, that the minute you encounter paragraph 28 in a dual agency situation, you have a conflict. Period, paragraph, end of story. So if you want to do it, you can do it. Understand that if anything goes wrong, that paragraph is going to cost you your entire commission.
Can you clarify that? So if it's in a dual agency situation, you just cross that out?
No, I'm not saying that. Because if you cross that out, you're acting to the benefit of your buyer, to the detriment of your seller. You can't act to the detriment of your seller unless you say to your seller, hey, listen, is it all right with you if the buyer reserves the right to sue your ass a year and a half from now if he finds out that the basement leaks?
We're going to agree with that.
Well, here's the better issue, and I'll get back to that in a minute. Here's the better issue. When you're sitting with your buyer, and this is true even in a situation where you only represent the buyer. When you're sitting with the buyer, are you explaining to your buyer that by signing the agreement with that paragraph in it, your buyer is also giving up the right to sue you? How is that not a conflict? You know what? I would love it if I could engage in retention agreements with all my clients and say, by signing this agreement, you give up the right to sue me if I screw up. Hey, it's in there. It's in there. I don't know how to tell you to finesse your way around it either way. All I can tell you is, if you decide that you're going to be a dual agent, you better make sure it's worth your while.
Buyers sue anyway, though, and this is in
Of
here.
course, buyers sue anyway. And what this release does not do is it does not release the defendants from their claims of fraud. Because the courts say, well, that's a release that releases the agent and the seller from his negligence, but the contract was procured by fraud, and you can't get the benefit of an exculpatory clause in a contract that you've only gotten because you pulled the wool over the buyer's eyes. Yes, sir?
If I'm only representing the buyer and I have fiduciary responsibilities to the buyer, then doesn't this statement go against my fiduciary responsibilities?
Well, that's
to
my
the buyer?
question. When you're representing a buyer, and the seller's represented by someone else from some other office,
Yeah.
you're sitting down with the buyer, you're saying to the buyer, this is a release. And what you're doing is you're releasing the seller and the seller's agent and me and my firm, Keller Williams, from any liability for any condition in the house that we failed to advise you of with respect to anything except for fraudulent concealment. So, is that in your client's best interest to have him sign that? No, it's definitely not. However, here's how you have to weigh it. If you advise your client to strike that out, the red flag that's going to go to the seller is that, hey, this guy's reserving the right to sue me.
Right.
I'm not taking this deal.
Yeah.
Okay? But the question is, the more important question is, how do you explain that to your client? And I think you've got to explain that to your client by first giving your client the opportunity to read it very carefully on his own and ask questions about it. It's legal mumbo jumbo. It's sort of gobbledygook. But basically, what that buyer is doing is he's giving up the right to sue you. Now, as you said, buyers still sue anyway. They do. But the negligence claims often get dismissed on the basis of the release, which sometimes it's not good legal strategy, and sometimes I avoid doing that because all that does is leave in the case the fraud claims, which we don't want to be in there all by themselves anyway. But there's a real issue here, and the point I'm trying to make is the issue here is with respect to dual agency. You're acting with that clause in or with that clause out, you're either acting to the detriment of the seller or to the buyer, and you have a fiduciary obligation to both, which you can't completely, in my view, legally fulfill. It's a very thorny issue. Yeah?
How does it work when Debbie's the broker and I have the buyer and Margie has the seller?
Better.
Okay.
Better. I always prefer to see if the same agency is identified as the broker for the buyer and the broker for the seller, I always feel relieved when I see two different names as the individual agents, because the communication then goes from buyer to buyer's agent, from buyer's agent to seller's agent to seller. I mean, that's the way it's supposed to work anyway. Practically speaking, I think we know that there's some shortcuts that are taken, but that's okay. I like to see two different, I like to see when that buyer walks in on Sunday afternoon, I like to see the advice being given, and I know it hurts in the pocketbook because it means giving up, half of what you're otherwise able to get. But I like to see that listing agent saying, technically I'm allowed to represent you, but I would prefer if I hooked you up with another agent in my office, just so there's no threat of conflict here. Yes, sir.
So if you do that, if I'm sitting in the open house, somebody comes through, wants to buy the house, I say, I'm going to give you over to somebody else, they're going to take care of you, I receive a referral fee from that other agent, do I have to disclose that I have financial benefit from the other agent?
If it's a referral fee, I don't think you do, no.
Okay.
No. I think you have to, the financial arrangements you have to disclose would be with an outside agency, because the commission's coming from the seller anyway. And it's going to be the same nut to the seller, whether there's two of you or one of you.
Right.
Yeah? Sir?
Okay, one statement, one question.
Yeah.
I look upon that dual agency in the sense that you cannot serve, you have two masters, and you cannot serve two masters. That's a statement. The question is, under a negligent claim, what's the standard of care? I mean, do we go back to the ethical rules of NOR?
Yeah. In a negligence context, in Pennsylvania, negligence is governed by the existence of a duty. When you drive down the road, you have a duty to keep your eyes open and to pay attention. And if you look away from the road ahead of you and inadvertently strike the rear of my car, you've not committed any sort of intentional act, but you've been negligent because you had a duty that you breached. Same thing in your contractual relationship with your buyer or seller. You have a fiduciary duty. It's the same thing. You have a duty of care. And the fiduciary duty that a real estate agent or broker has in Pennsylvania is governed by the Act, by the Real Estate Licensing and Registration Act, which you probably know as the Pennsylvania Code. And it's enumerated in there what your duties are generally, what your duties are if you're a seller's agent, what your duties are if you're a buyer's agent, and what your duties are if you're a dual agent. The duties under dual agent constitute, in my view, legal impossibilities. It can't happen, as your first statement noted, you can't serve two masters. When you have a negotiation going on and you're not only the communicator, but you then become the judge and the jury or the negotiator on both sides, you have a seller saying, hey, listen, I really want $500,000, but I can go as low as $490. And you've got a buyer saying, hey, I really want to pay $450, but I can go as high as $460. Both of those folks have given you information that is per se confidential and subject to that fiduciary relationship where you have a duty to each of them. And boy, if you weren't born yesterday, you've got to know that the number that's in the middle is where this could land. But the minute that you try to massage the thing to get it to that point, you're going to lose your license. So,
One more
yes,
question.
yeah.
What happens if you refer that buyer to your wife?
Well, do you like your wife?
Yeah.
That's not her. Wow, that was great. It must be getting late. Listen, you can refer the buyer to your twin brother, as far as I'm concerned, so long as you pay attention to the bona fides of the separateness of the transaction. That line gets blurred, I think, if you and your wife are team members or teammates, because
Well, and forget husband and wife, just team, period. You've got people on a team. They're advertised as a team, they are a team. So you refer to somebody else in that team, to me, that's dual agent.
well,
If
here's
it's
the
a
problem.
team.
The statute, the RELRA, the Real Estate Licensing and Registration Act, doesn't define team. There's no recognition of a team anywhere in that. In fact, if you look at the letter of the law in the Act, the law permits for the existence of a broker and associate brokers and or salespeople. It doesn't talk about unities within the sales force. It doesn't talk about people clubbing up together. I think that what you always need to be aware of is what we in the law call the appearance of impropriety. A judge will often recuse himself in a case if there's an appearance that there's an impropriety, even though there isn't really one. And that's what you have to be. That's what you have to be concerned about. And you have to conduct your business in that transaction. If you're going to have two team members working on opposite sides, I would suggest that all of your communications, or as much of your communications as possible, be in the form of emails back and forth. So you have a record that you're speaking on behalf of this party, he's speaking on behalf of this party. It's doable. It's not easy, but nothing's easy anymore, I guess. So let me leave you with one story that will hopefully demonstrate what I talk about when I say the most important thing you have to remember is not to wear a hat that you've not been assigned to wear. Don't wear the cop's hat if you're a fireman. Don't wear the fireman's hat if you're a crossing guard. And don't wear the appraiser's hat if you're a real estate salesperson. There was a young man who was born a Native American who grew up on a reservation in North Dakota. And a very smart young guy who, at the end of his high school years, was given a full scholarship to Harvard University. And he graduated at the top of his class. And he came out of Harvard and he was given a full ride to the Yale Business School. And he graduated with an MBA from Yale. also graduating first in his class. And he was asked to join every Wall Street firm known to man, given very lucrative offers and the chance to make small fortunes by going to work in New York. But he turned them all down because he felt that he needed to go back to the reservation and give back to the family and the society that had provided so much for him. So he goes back to North Dakota, and of course he's there the very first day, and they name him chief because they think he's the smartest guy in the world. He's going to be the chief. He doesn't know anything about being the chief, but he accepts the job. And as the first winter rolls around, the Indians come to the chief and they say, "Chief, should we start gathering wood for the winter?" And he says, "Yeah, that's probably a good idea. Why don't you go do that?" So they go out and they chop down a whole bunch of wood and they bring it all back and they pile it up in the public square. And they come to him at the end of the day and they say, "Chief, do you think that's enough wood?" And he thinks to himself, "How the hell do I know? But I'm not going to let them know I don't know." So he says, "Let me think about it, come back tomorrow." So they leave his office and he gets on the phone and he calls the National Weather Service. And he says, "Hey, can you tell me what the weather's going to be like here in North Dakota this year?" And the Weather Service says, "Well, we think the weather is going to be fairly severe." So the next day the Indians come back and he says, "I've decided it's not enough wood, go get some more." So they go out and they're going another couple days and they come back with another enormous pile, and the pile grows exponentially. And they say, "Chief, what do you think? Do we have enough wood?" And he says, "Let me think about it again." So they leave and he gets on the phone and he calls the National Weather Service and he says, "What's the update on the weather forecast for this winter?" And the National Weather Service says, "We think the winter is going to be even worse than we thought a couple days ago." So the next day the Indians come back. He says, "Go out and get more wood. We don't have nearly enough." So they go out the third day and the same thing happens. They go out the fourth day and the same thing happens. And by this time the entire public square is covered with firewood. So on the fifth day he says, "All right, let me think about this overnight. And, we'll talk tomorrow." He sends them out. He gets on the phone and he calls the National Weather Service. And he says, "Hey, listen, I don't know who you are, but I don't want to talk to you anymore. I want to talk to the top guy. I want to talk to the chief meteorologist for the National Weather Service because I need answers." So the chief meteorologist finally gets on the phone and the chief says, "Hey, listen, I got to know, what's the real deal about what's going to happen this winter? I keep being told that the weather's going to be very severe." And the chief meteorologist says, "Yeah, we think it's going to be really severe, like maybe the worst ever." He says, "How do you know?" And the meteorologist says, "We don't know, but have you seen how much wood those Indians are gathering?" So, don't be the chief, be the Indians. Okay, good luck.